Good morning and welcome to all the honorable guests. It's my honor to welcome all of you and today's guest speaker, Honorable Dr. Balram Gupta sir, Director at Chandigarh Judicial Academy, and Honorable Lordships, Ladyships from PNH and other state high courts, and other honorable judges joining from across India. I had received a lot of registrations, not only from PNH, but also from other states, which shows that members are really open to learn from each other, which is a very good thing. And I think platforms like these are just helping us to break the barriers. Today's webinar is on Let Coronavirus Not Impact Judicial Mind by Dr. Balram Gupta, sir. Now, this session would be from 11:30 to 12:30. I'll just share some housekeeping things that how this webinar will proceed further. Sir will start the session and it will be detailed out by Sir. And once Sir is through with his detailing, we will open this forum for question and answer round. You can post your questions later once the session is over, because I am assuming that a lot of your questions would already be answered by the time Sir would finish with his detailing. In the last, we will announce that you can now post your questions. Your questions would be read by me. I will post those questions to Balram sir, and then Balram sir will answer those questions. Now, to further ado, sir, first of all, thank you so much for giving your time. And now I will request you to please take the stage and help everyone understand how we can go on with this, sir. Sir, please, sir.
I can start now. Thank you, Mr. Gale. Good morning to everyone. I'm happy to be on this particular platform. And I'm also happy in regard to the response that we have got. COVID-19 is a challenge. It's one of the biggest challenges in human history, for that matter. And therefore, particularly the judicial minds need to be attributable in such a manner that such a challenge could be effectively carried out. During the COVID-19 period, number of babies are born, and they are being named as Corona Singh, Corona Gupta, Corona Sharma. Different names are being given to them. I happened to read a story, of a boy, 8 years old, named Corona in Australia. He loved his name. Corona means the crown. But he was being bullied by his fellow students in the school. He felt depressed. He felt very unhappy, uneasy about it. Tom Hanks, Hollywood megastar, came to be a victim and tested positive in this particular coronavirus process. Ultimately, the couple came out of it. And this young boy wrote a letter to Tom. How are you feeling? What is your experience being the corona patient as such? And he shared his concern that the fellow students are bullying him and he's feeling so depressed. Tom wrote back to him, "We are your friends. You don't have to feel about it. Be proud of the name that you have." And in that particular process, Corona, the boy, was presented with a typewriter, a branded typewriter, Corona typewriter. So a boy felt so happy about it. Another story, a lady in New Jersey, in a nursing home, 108 years old. She tested positive, and everybody thought that she would not survive. She had gone through the 2 world wars, the swine flu and other flus and various other calamities which had been over the century as such. Through her willpower, she came out of it. And therefore, one doesn't have to be absolutely so touched about this particular coronavirus. Be positive and things would improve in that particular process. Judicial minds are special minds, are thinking minds, are productive minds, are creative minds. They contribute hugely in various ways, particularly doing justice in difficult situations, in different situations as such. Like the present situation that we are faced with, yet their main object continues to be to do justice, whatever be the situation. Heavens may fall, justice must be done. That's what the need of the hour is as such. When I say that judicial minds are special minds, I wish to refer this morning to Justice M.C. Chagla. Justice Chagla remained a judge for almost 20 years. A judge of the Bombay High Court from 1941 to 1947, and from 1947 middle to 1958. He was the first Indian Chief Justice of the Bombay High Court, which means a judge journey spanning over almost 2 decades as such. During this entire journey, Justice Chagla reserved judgment only in 2 matters. You imagine in the open court he would dictate the judgment as such. When he was a young judge in the year 1941, he was benching with the then Chief Justice of Bombay High Court, Justice Beaumont. Heard the case at length, and suddenly Justice Beaumont says, I have lost my voice. You dictate the judgment. He dictated the judgment there and then. And after having finished, he told the chief, you should have given me some notice. And the chief responded by saying, young man, you didn't need a notice. You have done an excellent job as such. That is the kind of a judicial mind he had. Justice Chagla would never read any petition at home, only in the court. Would hear the matters, dictate the orders and the judgments in the open court. How is that possible? That speaks of what a judicial mind, without any kind of a stress, without any kind of other consideration except the judicial conscience, without that he is to uphold the rule of law as such. The only consideration to decide, to do justice, in accordance with law. That's the kind of a contribution of Justice Chagla's mind is. In 1985, after his death, his statue, the white marble statue, has been kept in front of the Chief's Court in the Bombay High Court with the inscription, "A great lawyer, a great judge, and above all, a great human being." That is the kind of a judicial mind, the contribution that the judge makes as such. In this particular backdrop, let me at the very outset take up the most concerned area of concern this morning, which has really bothered the citizenry and the people around the country, the migrant labor for that matter. We all know the story of migrant labor during the course of COVID-19. The matter reached the Apex Court 3 times, and the Apex Court did not intervene on any of these 3 occasions. The matter came up before different high courts. The Karnataka High Court issued certain directives after issuing the notice. The state appears, and in that particular process, the state provides and says that since the summit court of the country has not intervened, where is the question of the High Court intervening in a situation like this? It must be said in respect to the High Court. They said yes, they're conscious of it, and yet they exercise the jurisdiction to really carry forward the right or the rights of the migrant labor as such. From the Karnataka High Court, the other high courts followed. The Madras High Court, the Andhra Pradesh High Court. And on the other hand, there was a severe criticism as to why the Honorable Supreme Court has failed to really intervene in a situation of this magnitude. And in that particular context, certain articles were written and a letter was written on Monday, that is 25th, late at night, in the sense just before the midnight, by 40 different senior advocates from Delhi and Bombay. Yesterday, a 3-judge bench presided by Honorable Mr. Justice Ashok issued the notice and said that the state has to come forward to provide free transport, free food, and free shelter. That's the change that has come in. In fact, the story stands repeated. In the year 1975, when we had the internal emergency, 9 different high courts issued the writ of habeas corpus, and that right was turned down by the Honorable Supreme Court in ADM Jabalpur in the year 1976. In this case, the Honorable Supreme Court had taken up this particular issue and did not intervene. The High Courts intervened, and fortunately now we have a situation where even the Supreme Court has intervened in this particular process as such. You know, our courts, our judicial minds are open minds. Yes, I'm sure the only consideration could be as to how the state can provide all this. This is a serious issue, but also as to how the state can deny all this to them, what the real challenge as such, which now is being taken care. It is late, but late than never as such, is the principle for that matter. You know, what happens is criticism. Yes, nobody feels good when there is criticism as such. No motives should be ever attributed. Judgment being criticized on principles of law, on good foundation as such, on good reasoning as such, is absolutely understandable. My only concern is when we are faced with a situation like COVID-19, our judges, besides having the judicial minds, must be large-hearted for that matter. You know, this is the need as such. Judges need to be compassionate, large-hearted. I'm reminded of a recent judgment of the British Supreme Court in which they held that it is the Parliament, the British Parliament, which can trigger the exit from the European Union and not the Prime Minister. And the reaction of the media, of the people in Britain was, judges are anti-people. They can take decisions, decide matters which are against the judges for that matter, against the people for that matter. Judges did not at all feel. They were large-hearted, but they did what they thought to be the best in that particular given situation. I'm reminded of another story, the actual story that appeared in London Times long time back. The caption of this story was "Old Fools," with the picture of 3 members of the House of Lords given below that particular caption as such. And then the story was recorded in that newspaper, the London Times. One of the House of Lords member happened to come to India. He was interviewed by Fali Nariman, and he was asked, why did you not issue the contempt notice? They gave the caption, "Old Fools." You were undermined in the minds of the people as such. That member of the House of Lords gave a smile and responded by saying, old is a matter of fact. Fool is a matter of opinion. What was there to issue the contempt notice about? That's the kind of a balance of a judicial mind, which one has to really consider in that context. Why I'm sharing this? That the judicial minds are special minds, and therefore, in the stride, these are the hazards of the profession, of the service to which they belong as such. The only thing is, as long as it's healthy criticism, no motives are attributable, the situation is absolutely understandable. On the sensitivity of the judicial minds, let me also share another episode of good olden times. Justice R.S. Sarkaria started from the district courts, came to the High Court, got elevated to the Supreme Court and made rich contribution. While he was at the district court level, the matter relating to the richest landlord of the area was listed before him. The evening before, his father at home mentioned the name of that landlord. Justice Sarkaria felt so touched. He went inside, immediately in hand wrote his resignation and gave it to his father, that I would not like to continue if you would be making such a kind of a request as such. The father tore that letter, apologized to him, and said, "Son, I'm sorry." And the son did not talk to him for months together. That's the kind of sensitivity Justice Sarkaria had demonstrated at that particular point of time as such. And therefore, when we talk about the judicial minds, we have to keep in mind that they are special in all particular situations, and particularly in a situation like this, that the present situation that we are faced with. Another issue which has come during the COVID period is that of the virtual court versus the open court. We are so used to the open court system. Our constitution, our civil procedure code provides for open courts as such. Virtual courts became necessary because of the situation, the need, this is the requirement of the situation in which we are placed today. Question is, should the courts be closed down completely, or should we keep the process open and tailor it according to the situation as such? It is because of this reason that this has become possible to actually and factually provide this judicial process through the medium of the courts at different levels, through virtual court processes as such. It has been categorically said by Honorable Mr. Justice Dhananjay Chandrachud that the virtual courts are not a substitute for the open courts. But then technology has to be used when the situation demands. And it is in that context that this particular process of virtual courts has been adopted during this particular COVID-19 period as such, to provide an opening, a window, so that justice continues to move in that context. If the situation improves, yes, the open court system needs to continue. But then, particularly the young lawyers are more tuned to this particular process, technological developments as such. It's a challenge of the time. We must accept the challenge as such. That's the need, that's the requirement. Ultimately, I, for one, was thinking when the times improve, to the extent the open court system would be possible, must be continued. Otherwise, this technological development needs to be utilized effectively and in a more effective manner. You know, there is an advantage of this kind of development as such. It's less time consuming. We lawyers, many a time, continue to wait the whole day long in the court, waiting for the turn of a case. And at the end of the day, we feel it has been a waste for that matter. In this kind of a process, that would not be the situation. Secondly, our pleadings, the petitions, the written statements, the responses would be far more inclusive of various aspects which need to be really actually carried forward in that particular context as such. You know, it's a challenge in the sense you have to put in everything what you wish to convey, because your time in a virtual court system is rather rationed. It is not like the open court system. And therefore, this becomes less time consuming process as such. Of course, the task of the judges would be far more, in the sense to read through the pleadings, spend time on that. In the US Supreme Court, this has been the practice right from the beginning of more than 2 centuries back, 1789, the US Supreme Court. They have been carrying it out. I'm not at all saying that straightway finish with the open court system and substitute. What I'm saying is, let's give it a trial and have the best out of this particular process also, along with the open court system. Particularly in matters like the constitutional issues were involved. Yes, the open court system and what the lawyers argue. The entire constitutional jurisprudence which has developed is, of course, the contribution of our judicial minds, but the contribution of the bar in this particular process cannot be undermined at all, for that matter. Certain names come to my mind: Nani Palkiwala, Fali Nariman, HMCY, KL Mishra. They were offered the judgeship of the Supreme Court. They preferred to continue to be lawyers. Why did they prefer to continue to be lawyers? Probably you would think to make more money. That was not the consideration. Money was no dearth for them at all. but they genuinely believed and felt that they can contribute far more as lawyers rather than being as judges as that. And that history proves that particular fact. The kind of rich contribution that the Indian bar has made, particularly in the domain of constitutional jurisprudence. Of course, how well that has been knitted, how well that has been weaved by our judicial minds is another life story which any country can be proud of. I have been across different countries, and the manner in which the Indian judgments, Indian judges are respected, you feel proud of that particular fact. That's the beauty of judicial minds, that they can be so productive and contribute hugely in that particular process for that matter as such. Let me touch upon another particular aspect. We have been all through talking about the fundamental rights. The preamble makes the first promise justice. The preamble also speaks of fraternity, assuring the dignity of the individual and unity and integrity of the nation. In this particular backdrop, I specifically wish to take up the issue relating to the fundamental duties during this particular period, COVID-19, and how the judicial minds have worked in this particular context as such. Speaking in this background, the 42nd Amendment of the Constitution in the year 1976, which became effective on 3rd of January 1977, introduced a separate part, Article 51A, relating to the fundamental duties, and enumerated 11 different duties to be followed by the citizens of the country in that context. It is in this background that I wish to talk to you this morning, afternoon as such. Look at the situation. It was on the 6th of April, 2020, the Honorable Supreme Court, faced with the matter through the virtual court, exercising its jurisdiction under Article 142 to do complete justice, specifically provided and specifically said that duties are no more an option. They are the responsibility. Social distancing to maintain this particular aspect. We are going through the medical emergency, the financial emergency, the environmental emergency. I mean, all kinds of emergencies in the country during this particular period. And therefore, see, to talk about, to promote harmony, spirit, common brotherhood. That's a duty of every citizen of the country. On the other hand, what you find, the doctors being hit, the police being attacked, the health workers being attacked, and different kinds of situations we have gone through. It is true that the fundamental duties under the Constitution are not justiciable as such, not enforceable as such, though there is no such specific provision saying that they cannot be enforced. The Constitution is silent. The matter relating to the fundamental duties came up before the Bombay High Court also. They dealt with this particular issue in a very effective manner. The question is, what is the situation today? And if you are violating your fundamental duty, you would have absolutely no claim to claim your fundamental right in that sense. Fundamental duty would be a limitation on your fundamental right. We started with fundamental rights with directive principles. Directive principles also not justiciable. Ultimately, the directive principles have been harmonized with the fundamental rights. What I am saying today, it is the judicial mind which has interpreted this in such a manner that this parsimony of rights, directive principles, and fundamental duties, the three components have to be harmonized. Yes, the state has to play a role relating to the rights of the people. Yes, the state has to play the role regarding the translation of the directive principles. But can we deny that the people, the citizenry of the country, has no role to play at all in this kind of a situation? This would be a mockery and will not be acceptable at all in any situation whatsoever. And therefore, during this COVID-19, what we have been able to have a positive interpretation of reading the fundamental duties as integral to the entire constitutional jurisprudence. One of the duties is to renounce practices which are derogatory to the dignity of women. A matter came up before the J&K High Court recently, before the Chief Justice, Justice Geeta Mittal's bench. And the kind of effective directions which have been given, punctuated with the fundamental duty of renouncing the practices which are derogatory to the dignity of women, is demonstrative of the judicial mind, how it really can come to a situation to deal with a situation as such. This is the kind of a background in which we all have to see. The fundamental duty talks about the dignity. The preamble speaks about the dignity of the individual. Article 21 of the Constitution, right to life, again, speaks about to live with dignity. And the issue which came up before the courts, not before the courts, but otherwise before the society as such. A patient dying, the funeral is not to take place because he was a COVID patient. What a human tragedy. Even the last rites not to be carried out. with dignity as such. Yes, the medical science and other aspects we cannot overlook. But the kind of situations, people getting violent in those situations, one has to understand the situation. One cannot really allow the situation to go on in that particular manner as such. In short, what I'm saying is from 1977 January, when the fundamental duties became a part of the Indian Constitution, actually and factually, this is for the first time that the focus on fundamental duties have really emerged. And I'm looking forward, post-COVID also, that this entire system would merge with the fundamental duties also, which would give birth to a wholesome jurisprudence, constitutional jurisprudence. It's time when the citizens need to realize their responsibilities, their duties, and cannot take shelter behind that they are not enforceable, that therefore they are ignorable as such. Certainly not that. This would not be acceptable. Another issue, the freedom of the media, the press. Arnab Goswami's matter, for that matter, that was also a matter of concern. Such. We all know about the episode which took place. Number of FIRs were lodged in different states as such. The matter came up before the Honorable Supreme Court. The first issue that is a matter of concern. Surely the freedom of press, the media, cannot be curbed in that manner. Criticism is integral to any democratic constitutional system. It cannot be ignored. But the main issue which came up, of course, upholding the freedom of press, there's no denying that particular fact. Different FIRs regarding the same episode, the Supreme Court has said no to that. Yes, at one particular place, the FIR, and that case needs to be investigated and carried out through a fair trial in that situation. And therefore, all other FIRs no more be operative. That is one particular relief which was given as that. The second relief which was being sought in this kind of a situation related to that the trial should be shifted, transferred to the CBI court from the Bombay court. Now, even in this regard, the Honorable Supreme Court said he is entitled to a trial, but the forum he cannot choose for that matter. And therefore, that prayer too has not been allowed. That speaks of the judicial mind. And in this particular context, what I'm focusing this afternoon now is the issue that in the history of a country, in the history of the courts, different times come. Indian Constitution is the all-season constitution. It caters to different situations. It is capable of being molded. Our judicial minds are capable of molding according to the situation. And by and large, the Indian judicial minds have done that. That has been the beauty of this particular process. I would like to close my observations by saying trust and confidence in the institution is the main strength of the institution. The institution's strength safeguards the rights of the people. It's a shield for the grievances of the people. And therefore, it's a two-way traffic. People must not do anything which would shake the confidence of the public in the institution. And the judiciary, the institution, needs to live up to it. That is what the situation is. I'm happy that we have a good account of the judicial minds during this particular period. Thank you so much.
Thank you so much, sir. We already have few questions. Now I'll request everyone to pose the questions. I saw that there were few questions which were raised in the starting, but I think as the session progressed, few questions were taken back. I think they were answered during the session itself. So, however, we have a couple of questions. In the meantime, we can get more questions. I will ask these questions to you, sir.
Yes.
The first question that I have is the Indian judiciary well equipped with the function effectively in this COVID-19 crisis? And something similar to this, we have another question, so I'll club this question. The second question, which is related, is virtual court is better than no court, but are we not really, do we have technologically illiterate people who can run these courts?
This concern is a genuine concern. There are many who cannot really operate and carry forward this particular technology. We are making a beginning. In the beginning of any system, it becomes necessary. Pilot projects are already ready with the Honorable Supreme Court, and I'm sure we too in the Punjab and Haryana High Court have that system available. Trials need to be given. Demonstrations need to be given. People need to be educated. This is always true of any particular new system and new technology. I belong to a generation where I have a handicap. I'm not akin and familiar.
I know, sir.
My handicap is there. I make a confession. That's that. But there are many others also similarly situated.
Yes.
Absolutely true. But I'm sure, don't feel negative about it. We need to awaken and bring the technology. After all, gradually it has to take charge. And the benefit of it, with passage of time, we would certainly realize that. That is what is the need side. Lot needs to be done. Justice Chandigarh, who is chairing the E-Committee of the Supreme Court, is at it.
Yes, sir.
And therefore, in that particular process, I'm sure we are marching ahead. Let's look forward.
I understand, sir. I think it's also, a concern because a lot of courts are don't have equipments or they're well equipped with the internet facilities. Like even today, I was getting calls during the webinars that members were trying to reach and see this webinar, but the screen was blank, and that was only because the internet was really slow. But I think in that context, recently, 2 days back, Justice Chius Bob this up, has, I think, already directed the telecom minister to fix this issue so that the e-courts can work effectively. So I think earlier we were not really focusing on it because it was a choice. It was one of the options. Now it is the only option.
Only option. That's
So
right.
I think things will work. Let's see. I think we have more questions. So the judicial structure is mostly ignorant of technology. So is more than half of our society. How do we cope up with this gap of ignorance and the necessities of social distancing when technology knowledge is becoming need of an hour? I think, sir, you have already answered this question. I think if you want to add anything to it, I think the part of that, how can we, I think this is from Mr.
See,
Singla.
see, this is a gigantic problem, a big problem. There's no doubt about it. But then we have come reasonably moved forward in that direction. A lot more needs to be done. We need to equip our district courts, our high courts, and many other things. So far as you said it, it was optional. Now we are faced with a situation. And once you are faced with a situation, you always do certain things which would lead you to better results as such. That's my hope. I'm very positive about it.
I'm sure, sir. I think one thing which is very clear nowadays during this COVID-19 period, that, and there was a study on it, that people who were negative have now started being a bit more positive, and people who are positive who are becoming more and more positive. So I think it has done. I think something related to the same thing that some people are taking this period as an excuse for not doing judicial activities. So there is one question from a person who has not written the name. It's the question is that, do you feel that stakeholders are merely making excuses to maintain the status quo by pointing out difficulties in virtual court systems, especially the younger generation? I think, sir, you can, we have, I think, talked about it a bit, I think, but you can answer it.
Certainly. You know, I do not really think so.
Sir.
Maybe to an extent, in a very limited form as such. That depends upon how a particular mind works, accepts a particular situation as such. And therefore, I'm sure a little push, many a time to many situations, a judicial push is required. And in this particular kind of a situation, yes, a push is required. I'm sure we would achieve the results in that form.
Sir, I think a lot of questions are coming on the same lines. I think I'll just add my 2 cents of words with what you said, sir. I think for everyone who's on this webinar, there was a black swan event. This COVID-19 is considered as a black swan event of the century, which means that things which would have taken 10 years to come, it has come in 10 days or 1 month. So I think in respect to that, there's a question. The question is, I think the questions are something similar, but I think we can post it out. It says, we haven't adopted technology advancements of the past decades, like video recording the testimonies of witnesses in the court. Do we really believe we can transition on to the next stage flawlessly?
Yes. You know, let me go back to the year 2003.
So,
the Honorable Supreme Court, in one of the cases, recording of evidence through video conferencing, almost 17 years back, for that matter. This has been going on in many ways as such. And video recording, video conferencing, or presenting even those who are in jail, not to bring them to the court as such.
So
this is being done. And therefore this technology, as we grow, get into it, and realize the utility of it, the benefits of it, The mind is educated. E-filing for that matter, yes, many are not conversant with that. But we are moving in that direction. This is the challenge of the time, and I'm sure COVID-19 has helped us in pushing it. This is a big push which COVID-19. Let's take the push forward.
And I think because of this, the government is also understand that they have to stand up and give you all the facilities. They can't really put things under the carpet anymore. So I think
right.
things are also working from all the departments. All spheres are actually working towards it. So I think I think the questions are pouring in a very sequential manner. So we spoke about that, people have to think about means and methods to how can we make a benefit out of this pandemic. So one question is on the same lines. It says that is it not possible to record evidence through video conference by maintaining audio and video records of the evidence and by generating automated transcripts of the evidence as a part of the virtual court system? So I think in short, can we have record evidence through video conferencing, or yes or no?
Yes, we can do that. And this should be, I'm sure, the authenticity about it is being taken care as such. And this should be possible. It's absolutely need of the hour. Even otherwise, COVID or no COVID,
Sure.
we need to introduce this technology in regard to that. I remember having argued the cases through video conferencing before the Central Information Commissioner in Delhi. See, this system has been operative, going on in piecemeal process for the last almost, say, 2 decades, or maybe a little short of that. And therefore, this is now on a larger scale. We need to get used to it. Electronic evidence is the challenge. The rules have been framed in regard to that, and therefore, there would be no difficulty in regard to this.
Thank you so much, sir. I think it's going around in the same area that we've been discussing. In different forms we are talking about it. And I think the next question talks about that the challenges. So one thing we've been talking about is that the technology is one aspect, and reluctance is another aspect. The question now comes in do you think we need to work at full strength in district courts with technology? Judicial officers equipped with technology shall be deputed at the High Court level. So basically, the question is that every time there's a technology aid is required, we look up at the High Court, and someone from the High Court then comes in and does the needful. So the question in simple is that should we, have more people technologically, equipped, and they should be at the district court level so that things can be done at the district court level itself, and the High Court should not be bothered with these things.
Say, absolutely right. More and more people need to be trained into this technology.
Sure.
Yes, High Court is the main support system, the human support system in this particular process for the district courts.
Sure.
And in order to make it workable, that all district courts, through this particular technological development, even the High Court would be wanting to do that.
Yes,
this is a task which is larger now. I remember only a week or 10 days back, 14 courts were to hold during this particular period on a given day. And the entire staff, High Court staff, was engaged in that particular situation. Obviously, we need more hands,
right,
technically trained. And therefore, this gives an opening to many more.
Yes.
That's another offshoot of it.
Exactly, sir. And I think that's exactly, I think, what even the members honorable members who are joined us on this webinar, I think we are going on the same lines, because the next question says something similar. What you said, we need more hands. The question is that, so let's assume we all are well equipped with this technology. The court staff, judges are well trained. But I think should the public and the lawyers should also need some training?
Yes, I said so. In
Yes.
fact, already the module is ready with the Supreme Court, and I'm told that a lawyer from Delhi has prepared a module for this training of the lawyers, for
Okay,
that matter. And that lawyer has not charged anything. I'm
okay.
told that. See, that's the way the people are working and wanting to really contribute to this particular technological development which is taking place.
Exactly.
It would be very healthy. That needs to be done.
And I think, sir, what we are doing today as well, like this webinar. Earlier, members didn't have time, or didn't have that even that scope to reach out to so many people without opting for video conferencing, and that was very limited. Right now, I think I should put it on the record for everyone. So you and we had sat down yesterday to set this webinar up, and right now we have approximately 550 members who are watching us right now. So I think
That's
this
very
is
good.
the same example. We learned it yesterday, and we are now hosting this webinar.
Absolutely. You reach out to such a large audience, such a large audience. I mean, I remember I've been delivering lectures in auditoriums and classrooms, courtrooms and classrooms and the different places. But you reach out such a large audience. And I mean, this kind of a webinar on the YouTube, you put it, it goes across the country and beyond the country.
Absolutely.
That's that goes beyond the country also. That's
Right.
very useful. This is the benefit. We are the beneficiaries of this technology, for that matter. Certainly.
So now comes the main, I think there's one major concern, because when you are in a courtroom, there's a lot of, I'm not supposed to use this word, but this is the word used in the question. There's a lot of melodrama that happens in the court. It's a really live session that, brings up the entire court alive. So the question is that how far virtual courts affects the magic of live court hearing? Judges will not miss the melodrama of courtroom hearing, and will the virtual court hearing not make it all very dry?
Good question. I'm very happy that this question has come forward.
Sure.
I'm used to the open court system. And a good lawyer needs to understand the judge, know the judge, not knowing the judge otherwise, but to know the judge.
Yes, sir.
Know the judge, what he likes, what she likes, the factual canvas, the law point, and what kind of a recipe which really goes for a particular judge. I remember my professional days. At that time, the cause list would come in the morning only. We never used to have that cause list earlier in the evening. And you are waiting for the cause list. When you get the cause list, you come to know that your this particular case, fresh filing, is fixed before a particular judge. Now, the lawyer's mind works that what this particular judge likes the most, and you prepare mentally yourself as such. I'm not using the expression melodrama, certainly not that. But the kind of interaction which takes place between the judges and the lawyers, that brings out the best from the lawyer. The courtroom environment is very important. Why do I say that? A congenial courtroom environment is important to extract the maximum, the best possible from the lawyer. I am reminded of K.L. Mishra. He was the Advocate General of the UP High Court, Allahabad. About him, what was being said. He used to be practicing in Allahabad, and seldom that he would go to the Supreme Court. he would argue the matter. Chief Justice S.R. Das in the open court remarked, Mr. Mishra, why don't you come more often to the Supreme Court? The standard of her judgments would go high. The lawyers also make contribution in that process. True, the author of the judgment is the judge. Yes, but sir. What goes there? What goes into it? It's not the melodrama. You see the reaction when you are arguing a particular point. You see the face of the judge, you see the reaction of the judge, and you mold your further arguments in that particular point.
Certainly, sir. Certainly.
And therefore, there is no substitute for an open court, I would admit that. And that's how we have been able to produce the best of constitutional jurisprudence, which I would not say about the US Supreme Court, because there the time is rationed altogether.
Right.
Good.
So, but I think, so like you said, the open courts are something that is real and people really enjoy it. So I think I still need that question, considering that we are now going totally virtual. So are you saying that there will be a dip in that essence of the open court? You will not be able to get the same flavor through virtual courts?
See, I'm sure in certain matters of constitutional importance,
sure.
The open court system would be possible and should be possible as that. But live telecasting and say an advocate who wishes to argue that particular matter sitting in Bombay High Court, he could, through video conferencing, could be addressing the Constitutional Court also. Yeah. You see, that kind of a benefit, the Canadian Supreme Court, Canada is such a vast country, large country, population-wise, no, but otherwise.
Area-wise, yes, sir.
Yeah. Area-wise, yes. And therefore, imagine people sitting in one corner of the country arguing the matter, and similarly, it can be possible here also. And therefore, you have to draw the balance sheet. There's a plus, there is a minus, but ultimately a balance has to be struck.
Absolutely.
The two have to be.
Yes, that makes a lot of sense. There'll be a lot of things that you have to give up, and you'll gain a lot of things as well with that. And I think with both things in hand and making a balance of it, like you said, is the future for the court system.
Absolutely.
And I think the small question that will it affect the virtual courts will affect the fair trial? I think you have already answered that. It's saying that will the virtual courts will affect the fair trials? I think you've already answered this, that it's just members are there. So.
See, let me put it this way. It will not affect the fair trial. Let me put it this way. See, basically, those who wish to be present are the parties, and the parties, for instance, I am on behalf of a particular party. I'm arguing on behalf of a particular party. That party is sitting where I'm arguing from. And maybe some of his other colleagues whom he wishes to bring, they can sit back aside. Here, even in court, the lawyer is arguing, others are hearing. What happens in the High Court or in the Supreme Court? The cases are fixed. And all those persons who are coming, say, from the different departments of the government, representing the different departments of the government, they would come in the morning, sit through, whenever their turn comes, only then. They are all sitting aside. Here would be a situation where, well, the judge, the lawyer, the parties, they have complete access to what is going on. They would be watching everything else. And therefore, I do not see that the fairness of the trial would be impinged upon or impacted negatively. Certainly not that.
Absolutely, sir.
Yeah.
And I think we also got, in a question, we also got some praise that members are saying that we're liking this, technology that we are able to reach to so many people through webinars. So I think there is a mixed opinion. I think people are now going forward with these things.
Absolutely.
So we spoke about that we can record evidence. A few minutes back, there was a question that we can record evidence in criminal trial. The question is, and I think you can just probably reiterate, the question is the same. It says, how can we record the evidence? The first question was that can we, but now it's about how can we? What is the process? What should the process follow, sir?
See, I'm sure in the court, the persons who have to record everything, technologically recording what the evidence is, also manually the recording can be done as such, and thereafter the two can be read, considered together, and final transcript can be taken out in that shape. That should be possible. I mean, these are minor nitty-gritties of the situation.
Which can be addressed.
Which can be, they can be knitted well. They can be knitted well.
And I think, sir, now, once we're done with this, like you said, that we can record the evidence through this. Now comes the question which is talking about that what is the authenticity of these documents? Because these are not being presented before the court physically. It says that because of the era of technological advancements, can we ensure the authenticity of these documents is right or they are genuine documents?
See, different minds are already involved in this exercise. And what process has to be worked out. They're working on that. And I'm sure they would come out, which would be to the satisfaction of most of the people. You can't satisfy one and all, but I'm sure it would be largely satisfying the people. They see the minds are working on this.
Yes, sir.
I mean, you are looking forward to a vaccine to deal with the corona as such. The work is going on in regard to these different aspects as well. I'm sure they would work it out largely.
I think one of the judges are also agreeing with you. I think K.S. Bajwa sir has written something. He is sharing some information. He said, we already have the rules to save audio video recordings. Please see Rule 8.9 of Model Rules circulated wide letter 670 dated 21st of May 2020 by Honorable Registrar General of PNH High Court.
That's right. That's right. Well, I told you that it's being worked out, and it is already worked out in a way, and therefore nothing to feel that this would be something where, I mean, kind of cheating, fraud, and all that. See, that has been going on in spite of the system that we are already used to. And therefore, this also needs to be worked out. I'm sure there would be no difficulty on that score.
Sir, one question which talks about, now this is the courtroom problem pertaining to, one of the judges, sir, is saying that there's a struggle when they encounter in running a court smoothly is the lack of language proficiency of a stenographer. So is it really difficult for me to dictate a judgment in the open court? How can that be addressed?
Yes. See, now, at this particular aspect, dictating a judgment in the open court is something which you gradually get used to it. It's not everyone's cup of tea. I totally agree with that. You need a different kind of a confidence to dictate a judgment in the open court. I was giving a reference of Justice M.C. Chagla. In his entire judicial career of almost 2 decades, only 2 judgments were reserved, otherwise dictated in the open court. And those 2 judgments also he reserved because he wanted to bring uniformity. Means you are a judge, I am a judge in that particular bench, I'm not agreeing with you. And he wanted that it should be a consensus judgment. Therefore, the stenographer should be available to the judges at home. Now, even on the computer, the entire system, you dictate, and that is possible. So this technology to an extent is being used even with the judges in that background. All are equipped with the laptops and with this particular system.
Right, sir. And I think even the mobile phones are now, I think everyone has a smartphone, so even things can be done through mobile phone itself.
A lot of it can be done.
Yes, the question now is about, so we talked about the court system and all. Now we're getting into the mediation side of it. So the question says that in the virtual courts, especially the family courts, where the presence of parties is essential for mediation, how can we run virtual courts in it? I think you can just give us some clarity on it, sir.
See, I don't think that there should be a difficulty in that regard. The parties are there. The one who is mediating,
yes, sir,
is also there. As that. Parties are sitting at two different places, of course, not at one particular place. Yeah. And therefore, in that context, you know, one party says something, for instance, to a particular proposition that why not do it in this particular manner? You see, mediation is a very gradual process, negotiating process. Gradually, you are not judgmental. You are gradually bringing across as to how we can march in that direction. Now, for instance, there is a move from one particular side, say something, maybe that the response from the other side comes in. And therefore, I'm sure even for mediation, this can be a very good medium to carry it out. Mediation is the need of the hour. Consumer Protection Act has been amended, and virtually a new Consumer Protection Act has come into force. There, on a large scale, first the matter is to be referred for mediation. When the court is confronted with the case, is filed in the court, it would be referred to for mediation purposes. If I use the expression, we are trying to make mediation fashionable. It is in fashion today. And let us see, it can bring good results. Even in the Ayodhya matter, the effort was made through the mediation process, though of course it could not be achieved. That was a gigantic effort as such. Right, but I'm sure in due course of time, through virtual mediation court system or mediation system as such, even this should be possible. I mean, it's a meeting of minds, and meeting of minds is not necessarily when you are sitting together. It's much easier, I'm sure that is, but still it should be. And I, for one, would say mediation, the normal rule should be you sit together, do it. Wherever it is not possible for reason 1, 2, 3, only then resort to this version. Virtual. Yeah. That is the best way out for this.
I think the mediation will not stop.
Certainly.
With this, it will just only accelerate the process.
Absolutely, absolutely.
And sir, I think there is, I don't know if there's any notification in pertaining to that we can use a particular software for this, because the next question from Ekta Uppal, ma'am says that can we use mobile video calls app as an alternate in situation when video conferencing is not feasible?
Say, I do not know whether the rules have been framed and whether this would be permissible as such or not, but I'm sure this is something which must be under contemplation, and some way out would be worked out for this kind of a situation as well.
Yes. So considering that the last discussion we had about mediation, so we have video conferencing option in the courts. However, if the parties are at different places, they would not be able to go to the court, to that particular district court, and then ask for a video conferencing software. No one would allow that. I think in those scenarios, they have to use the personal, mobile apps that to come.
That is right, absolutely right. It's, the smartphones are now something which really help you out. I mean, in the sense, in different situations, you can do what you could not do earlier. So difficult, for that matter. I mean, I remember now. Let me share one small background.
So,
When I did my doctoral work, way back in 1975 and thereafter.
okay.
We didn't have computers. We had only the manual typewriter. My professor in charge, who was supervising my work, he was a visiting professor in Zambia.
So,
I used to write my chapters in hand, retain a carbon copy of that, send it by post, retaining the carbon copy, thinking that if in transit it is lost, I have something with me. I mean, this is what is the situation.
Right, sir.
And my Tauji did a PhD thesis way back in 1935 in the domain of mathematics. He wrote 4 copies of his PhD thesis in hand because you didn't have even the typewriter of mathematical terms for that matter. And therefore, technology really helps you in various. I mean, I am myself facing that situation and experiencing that. That is what.
It is, sir. It is.
Yeah.
And I think you already answered this question. It's regarding the mediation. Someone is saying that usually when we are going through the mediation, both the stakeholders, the husband and wife in this context, they already have a gap. They don't really talk to each other that easily. The question is that will the video conferencing will widen the gap or not?
See, it needs to be, you need to wait and see how things shape up. I'm sure with the effort which is being put in, there would not be more of spacing. We will be able to merge the spacing with an effort to put in. I was involved in the matrimonial matters at the High Court level, reconciliation and all those things. And I can well appreciate the magnitude of the problem which you are referring to in this given situation. But I'm hopeful even that should be possible. And those are things, situations, mediation in matrimonial matters. The two parties, the mediator sitting together, social distancing can be easily maintained, and you don't need to resort to the virtual mediation centers as that. You can sit at a place of your choice and work it out. There should not be a practical problem with that.
I think we just have to go with the flow and see how things are going to turn out.
That's right.
There's another question, sir. I feel the virtual court is a great initiative for the time being, but why don't we also think of going green and paperless for the times to come? As it will not only be a contribution towards environment, but also reduce paper. So I think it's about a praise that we should have we are glad that virtual courts are coming in, but more of e-courts is what I think Harsimranjeet Kaur is asking right now.
I didn't get the question exactly. What is the question?
The question is that we are talking about virtual courts, but we should also have more of e-courts to minimize the paperwork, to go green and to save the environment.
You are absolutely right. the e-filing system in the Supreme Court, all the 17 benches, e-filing has been worked out already. The system is in place over there. And e-filing system even in the Punjab and Haryana High Court has been worked out. It's a question of the lawyers accepting that. And therefore, once it is made, I mean, there has to be education, training in regard to that. Once it is done, there would be no difficulty to my mind. Yes, we need the e-filing processes also if we want the virtual courts to work in that context.
So, sir, about the Arogya Setu app, which we've been directed by the Honorable Prime Minister of India, that we need to use it. Now, one of the judges are asking this question that how can we implement in the court? So people like petitioners are coming to the court, the parties are coming in the court. How can we implement that? I think that is the one major challenge that judiciary is facing right now. So do you think that can be that should be addressed in this part of the session?
See, this particular aspect, to my mind, one, it is to see as to whether that particular person is suffering from this particular, the corona, is he positive or not? Am I right? This is the question that you are, and his entering the court premises may be a threat to others in that context. Now, this is
yes.
Is this the question as what is exactly the ambit of the question?
Sorry,
hello.
Sir, say it. Can you say it again?
See, the question is why this particular app is being used to ensure that the person entering the particular premises does not suffer from this particular virus and therefore is not a threat to others who are.
So the question is a bit different. The question is that how can we, as a judges, as judiciary, how can we, emphasize, or how can we impose that everyone who's coming to the court has the Arogya Setu app in it, in their phone?
See, the question is, it has already been introduced, and they said that this has to be, if you want a particular kind of the service for that matter. Now, this is also a responsibility which is cast upon, and if the system is worked out, I do not think that there would be a challenge to this security or other aspects, unless there's something deeper to that. I personally don't think that that would be an issue in this context.
So, and I think the next question answers the question, the previous question, that DLSA, the Legal Service Authority, should also come in helping the technologically imparting technological knowledge, and also ensuring how can we put up a system in place so that members who are coming in the court can be checked that if they have the Arogya Setu app or not.
Absolutely right. I'll answer this question. See, the legal services authorities at all levels, they need to play a very positive role during a period like this COVID-19. They have a definite duty, obligation to work out different ways as to how best this can be carried out. There can be a very good support system, and therefore this must be exposed to the maximum for the utilization, migrant labor and others who are in need of their services. Certainly, Mr. Puneet Jindia has written a very good piece in regard to the services which can be made available through the legal service authorities at different levels altogether. And therefore, let's make best use of them. they need to be, the services need to be utilized. There's no doubt about that.
So I have one last question, and I think this is, till now we've been talking about judges, we're talking about other aspects, technological aspect, but I think this question is, I think is a very good question to close this webinar. It's the question is about about the feelings of litigants, feeling of the parties. It says that litigants are foundation of the court. It is a duty of the court to make the litigants believe that they are being heard. But in case of virtual courts, it is difficult to make litigants believe this. Advocates and judges can easily adopt to this new technology. But until the litigants believe in the same, it will be difficult to use this same effectively. What are your views on it, sir? How can we make the litigants believe that this is the same way we were dealing with the courts earlier?
Good. This again, as you said, is a question which is going to make trust and confidence in the institution of judiciary of the public. Certainly, the satisfaction of the litigant is most important. And only thing which a lawyer and the litigant wants should be heard properly. Long hearing is not a fair hearing. Let's not mistake and put the two together.
So,
fair hearing can be a short hearing also. Two, whatever you wish to say in detail, you can put it in writing, which is the advantage of the virtual court system. The parties sign the petitions, they know what is written in that, and therefore it is being communicated to the judicial mind, the judges. But my main emphasis is a fair trial means hear properly, not longish hearing is the recipe for building up the trust and confidence. Maybe a short hearing, yet an effective short hearing is the solution to the given situation. I'm sure the parties will be satisfied with that. There should be absolutely no problem related to this. This is something I, as a lawyer, experienced one particular thing. See, senior advocates don't meet the litigant directly. His junior will meet and hear the party and then drop the petition which goes before the senior. One of the grievances of the litigant is, I must be heard by the lawyer who is to argue for me. Now, first the satisfaction of the litigant vis-a-vis the lawyer, and thereafter the lawyer to put it across, maybe briefly, shortly, but how aptly he puts it across, that is what really matters. And I'm sure his job will be done well if this is done. Thank you.
Thank you so much, sir. There's a very nice poem someone has posted in the question by Mr. Prashant Rana. I think I'll publish it for everyone to see. It is talking about, it's a very long poem. I don't want to take everyone's time, but I'm going to publish it so people can see it. It's talking about the same thing that there has to be a time when the knowledge is free. People can talk to each other without fear, and that's how we're gonna reach new heights together. So I think that is what exactly we are talking about. We're not really, bowing down towards in front of this COVID-19. We are finding alternatives, and I think, like sir, you said that we are facing challenges, but one thing is very certain, that we're not really ready to give up. So I'm sure that today's session, a lot of members would have got their answers to the questions by thank you so much for sharing your wisdom with us. And I think, sir, I'll, on behalf of everyone, I would like to thank you. Thank you so much for giving your time. And I would like to thank all the honorable members who had joined us for this session. And we have a session tomorrow as well by Dr. Arora sir. But for anyone who joined from Punjab, Haryana Judiciary, from other state judiciaries, thank you so much. And I hope this session was fruitful. I hope the session was interactive. We couldn't answer all the questions because the list was very long, so I had clubbed a lot of questions. I hope the question has been answered. On behalf of everyone, and I would like to thank you, everyone. Thank you, Balram Gupta sir, Dr. Balram Gupta sir, for your time, sir. And now we will close the session. Thank you.
Thank you, Mr. Bell. Thanks a lot.
Thank you so much, sir. Thank you.
Thank you.